I'd like to talk about tips on resolving discovery disputes. A major misunderstanding is that judges hate discovery disputes. It's not true. What judges hate are discovery disputes that should not be brought before them. Judges enjoy discovery disputes that have real legal issues and real factual issues. However, 90% of discovery disputes don't involve either. It involves attorneys not getting along with each other. The main complaint you hear from judges is that they are acting like school teachers to a bunch of petulant children. You don't want that. All courts have rules concerning how you resolve discovery disputes. All of them require communication with each other. The problem I see is most attorneys will either email someone very short, very brisk, and there is no communication. There is no real effort to try to resolve discovery disputes. If you really want to make the judges happy and be successful in resolving discovery disputes, talk to the opposing counsel. Don't email them. Don't send them letters. Speak to them either in person or on the phone. Be flexible. Talk about what is their real concern. What is their real goal? The reason that judges don't like discovery disputes is 90% of discovery disputes could be resolved if attorneys talk to each other and resolve things in a flexible way. I can't tell you the number of hearings I've had where the only dispute is whether a particular party is going to appear Friday or Monday. The judges don't like that. Be flexible and resolve these disputes. You also can't let your client run the show. You have to have client control. You have to make sure your client understands they have to be flexible. They have to understand that if they're not flexible and you take this sort of trivial dispute to a judge, the judge is going to be unhappy. Now, sometimes the opposing counsel are unreasonable. And the question is, what do? I'm reasonable, I'm flexible, my client has given me permission to be flexible, but they are not. And what you do is you make sure you document what has transpired. You make sure you document what you've said, what you've offered, and their response. That you can do by an email. Make sure you attach it to any motion to compel or an objection to a motion to compel. Finally, if you reach an agreement, make sure you put it in writing. Make sure all of the details are there so there's no misunderstanding. Include any deadlines for which they must comply with whatever agreement you have. If you have an attorney who refuses to communicate or refuses to return your calls, you also document that. Send them an email indicating, I've called you 2 or 3 times, you've not returned my call. If you don't call me by X date, I have no choice but to go to the court. Again, include that email to your motion, and the judge will be more favorably inclined to rule for you.